Okay, basically we've got the exam set up for Monday, and I think I announced this in both classes, but I'll go ahead and announce it again. It's going to be in Macklin Tower 205. It's one of the computer rooms on the second floor in the library, and I'm going to have it at 8:30. It'll go from 8:30 to 12:15. So doesn't matter if you're in the 9 o'clock class, doesn't matter if you're in the 10 o'clock class. If you want to come in there early before your class and take it and get it over with, that's fine. If you want to come in late and stay later, that's fine too. I think there's 38 seats that are in the room, so it could accommodate a lot of people. Hopefully there will be, enough spread out so that nobody's got to sit on the floor or anything, but it should work. The only thing I can't do is I can't let you start to take it and then leave and then come back. That's the only thing I can't do, but otherwise you can come earlier and stay. If you really wanted to, I guess you could stay the whole time, but hopefully you won't need to. I'm in the process of finishing up the exam now. It's roughly about 30 multiple choice questions, and it's going to be either 5 or 6 short answer questions, and it's going to be the exact same format as the first one, so all the multiple choices, and then you're going to need to answer a choice of 5 or 6 of the short answers. So I might give you 9 or 10, depending upon if I give you 5, I might give you 8. If I give you 6, I might actually give you 10 possible choices to pick from. Go ahead, Ben.
You said before that you were going to take something away, the X Factor?
I've actually said, no. We'll get to that in just a second. So why don't we just start with some of the chapters, and why don't we just start with chapter 5? What questions do y'all have from chapter 5? And I'll pull this up. So we've got chapter questions, we've got terms, we've got links, we've got articles. What do y'all have? Go ahead, Lisa.
The Cheryl Parrish, I wasn't sure how to answer that question.
That's the one about the lady that I believe had gotten diagnosed with narcolepsy, right?
Right.
Okay, she was the one that was diagnosed with narcolepsy. She went to the doctors cleared her, and she actually worked at a religious school. And the school evidently did not want her to continue working there. And then she ended up suing when they would not renew her contract because she had not given them any reason but for that particular illness. Go ahead, Ian.
Isn't the medical history confidential?
Well, not according to the chapter, so let's not worry about that piece. But this was one of the chapter questions. And when they did this, she actually was, when she was released, she sued because she thought this was a violation of the Americans with Disabilities Act. And then the Supreme Court actually said that churches and church schools in this instance have the ability to fire somebody if it was based on race, if it was based on disability, if it was based on gender. They actually said the school won.
So they could.
They could. And technically they were discriminating against her, but basically the court had deemed her as being kind of a religious leadership type of a person, and they said that it is not government's job to determine who a religion's leaders are. So yeah, it was legal technically to discriminate against her. And it may be confidential in a number of instances, but for this one, I guess she made it available. Yeah, go ahead.
The court's decision was based on her religious role primarily?
Primarily, yeah. Well, and even that was debatable because a lot of the subjects that she taught were not religious subjects. It was like math and gym and things like this, but she did have some seminar hours, and the court said that it is the church's role to determine who their leadership is, and that the courts are not going to get involved in it. Not going to get involved in it. What other questions have y'all got? Maybe from terms, from chapter questions, from articles for chapter 5? Go ahead.
I just want to, I kind of forgot Plessy versus Ferguson.
What was the Plessy versus Ferguson case? Samantha, you were all over this when we were... Okay, go ahead, Toby.
Separate but equal?
Separate but equal. Do you remember who Plessy was? Homer Plessy was?
1/8 black man.
1/8 black man, that's right. 7/8 white technically. So it was not his, well, let's see, I'll have to put it on the board because I'm going to get the math wrong. It was a circumstance where you had one white parent and one black parent, and when they had a child, technically you could say that this was biracial or half and half. Then they had a child with a white person, it was 1/4, and then they had Homer Plessy, who became 1/8. So parents, grandparents, basically one of his great-grandparents was black, so he was extremely light-skinned. And what was he trying to gain entrance to? Whites only train car. How did they know that he was still technically legally considered black? He told them he wanted to get caught because he wanted to challenge segregated train cars in Louisiana. And when he challenged this case, he didn't win, right?
No.
What was it that the court said?
If it was separate but equal, then it was equal.
If it was separate but equal, what do you mean? If it was separate but equal, then it was
They
equal?
had two train cars, even though that they weren't equal, but they were separate. Like say two train cars, if there was one in the front that got all the steam, but one in the back. They at least had two cars, so that was equal. They had two facilities.
Okay, I know what you're trying to say. Go ahead.
I mean, it's legal as long as they're separate, but in accommodation they're equal.
Yeah, so as long as the cars were the same size, they had the same number of seats, they had the same number of windows kind of thing. And the court said in this instance, yeah, in fact, this is 100% perfectly legal. The key words from Plessy versus Ferguson are separate but equal. And this was the case that designated this. And this was American policy up until Brown versus Board of Education. And one of the things we talked about in class was separate but equal was the policy. But the reality in many places was separate was not equal at all. Go ahead, James.
Brown v. Board of Education, I think you mentioned it was a black girl who wanted to go to a white school around
That's
the
right.
neighborhood. But in the book, it actually mentions it was like 5 different cases.
There were a number of different cases.
So
The
for
one
the-
that I focused on was actually the Topeka Board of Education part of it. There were 5 cases that were from different
So-
states.
Yeah, so
If
which-
you want me to require you to
No, no,
know
no, no,
all
no,
the
I-
facts
no,
about those
no, no,
5,
no,
we can
no.
do it right now.
No, I'm just asking you.
Okay.
So you're just asking about the girl.
Yeah, that was the basic one. Go ahead.
You also said that, yes, for Plessy versus Ferguson, they did not win the case, but you said there were multiple cases that were not won, but in the end, the main objective was to show how it was not equal, you said?
With Plessy versus
No,
Ferguson?
no, the Plessy versus Ferguson, yes, they did not win.
Right.
But you said, I don't know if it was like the whole,
It was like to point out the flaws.
you guys, the
and
flaws,
so-
like they were winning
I had
small
given
court
you a lot of
cases.
different examples of ways where separate was not equal. And I talked about like water fountains and garden hoses. I talked about bathroom facilities.
No, but you were saying like how different cases, they did not win, but eventually when it went to like a higher case in the Supreme Court, they showed, well, we have these different cases, we didn't win. You said,
I think what you're talking about was Thurgood Marshall. Go ahead, Samantha, help him out.
Thurgood Marshall was this like really like high up lawyer who did all the court cases to go against that. So they did multiple court cases and they kept on winning consecutively.
They did. They actually won consecutively. And if you remember, the small cases, they were dealing with education. If they would have started with the public schools, like they would have just jumped in with the big case, they would have been crushed because that would have been too big of a deal. But they started like with the law schools and the graduate schools and progressively into undergrad. And the argument is, okay, these are going to be the most educated people, and these are also going to be the schools where the fewest people of color are actually enrolled. So these are going to be minor changes, but they're going to establish case law where separate but equal can be struck down. So there were a series of smaller cases, and then progressively they won. They just kept winning and winning and winning. So when they finally got to Brown versus Board of Education, all of the case law said, hey, you've got history behind you. But then there were other arguments that they made. What was the deal with the Brown case?
That
Go ahead.
like they're like okay so.
Go ahead, Ian.
Brown had to walk through multiple dangerous areas, and she just wanted to go to a closer white school for safety reasons.
Yeah, she would actually have to walk miles in order to get to the segregated school that was actually in the Topeka, Kansas school district that was in question. And if you go back and you look at this, she would have to walk through some dangerous areas. She had to cross railroad tracks and things like this. And not only that, but it was one of those things where, she was doing this when it was dark in the morning or, with the time change dark at night. And ultimately, she just wanted to go to the school that was basically, just around the corner, and it was a whites-only school, though. When this got to court, what was the thing that really swung the justices to be able to strike this down, this separate but equal policy? Because it wasn't necessarily a legal argument, was it? What was the doll test?
It was basically where two races came in and they gave them like 2 separate race dolls, and they if you want me to go further.
Yeah, go ahead, go further. Don't be shy. And zoom in on Toby. Let him go further.
So what they did was they had black kids come in and they give them white dolls and black dolls, and they say like which one you are, and they're obviously gonna say the black doll, and they should ask you which one you want to be, and they point at the white doll, and it shows that if this is showing that, you know, I wanna be another race, cause they're being treated better, and to show this was not, separate was not equal.
Yeah, they would bring in the white kids as well, and you can stay zoomed in on Toby, that's fine. Understand on this, they would bring in the white kids and they would ask the questions about the dolls, and they would choose that they were the white doll and that was what they wanted to be. When it came to the black dolls and the black children, however, was very, very different. Just like you said, they knew that they were the black doll, which one are you? But they wanted to be the white doll, and the court ultimately held in Brown that separate but equal was inherently unequal. And they said that they were stamping these kids with a badge of inferiority at such a young age. They knew what they were, but they wanted to be something else, that they would never be able to overcome this. So they struck down segregated schools in Brown versus Board and effectively overruled Plessy, which was separate but equal. Go ahead.
I don't know if we covered this in class, but didn't they also say that these schools, these segregated schools did not technically have equal education?
Yeah, you could make that argument, and this is where you go to that point about talking about just because it was separate, it didn't necessarily mean it was equal. If schools didn't have books, if schools didn't have desks, if schools didn't have the same facilities, these kinds of things. So yeah, that's a fair point. What else do y'all have? Because I know I saw some hands. Go ahead, Nicholas.
The Commerce Power.
The Commerce Power was actually where they started dealing with segregation issues. And it was where the legal basis came from. So like if somebody bought a bus ticket on an interstate bus, like a Greyhound or a Trailways, they started there, and the federal government's argument was, you're involved in interstate commerce, you bought a ticket, which is a service, you cross state lines, we can regulate, we can desegregate. So it wasn't even a moral argument in the beginning, it was just a legal one.
What about the thing about the prostitutes going over state lines?
That was from the first exam, so don't even worry about that.
Okay.
What else have y'all got from chapter 5? Gotta go. Go ahead, Ben.
Page 104, what discrimination? G.
Invidious discrimination. What was invidious discrimination? Well, let's go ahead and address that right. Go ahead, Michael.
Is it the one where like the government when they were choosing states?
The government when they were choosing states. May I borrow yours? Let me go ahead and give you this. And this is a quickie. And I'll make sure that you've got it now, and I'll put it up here on the big screen. Believe it or not, as crazy as it sounds, discrimination is actually legal.
Was the population?
Discrimination is actually legal. And bear with me while this heats up for just a second. And this is going to seem a little bit crazy or a little bit off. But you'll notice here, this is just on page 104. It says, the court has said that it prohibits only invidious discrimination. That is, discriminatory acts that have no rational basis. So, like, if you're 21 years old, let me rephrase that. Until you're 21, you cannot legally drink, right? Until you're 18, you cannot legally vote. Until you're 16, you cannot legally drive. The rational basis, maybe it's maturity, maybe it's physical stamina. I'm not entirely quite sure what the reasons would be, but they have established these. Technically, that's discrimination, but there's a rational basis for it. If you say that somebody cannot do something because she has blonde hair, well, that's actually something that doesn't have rational basis. That's invidious discrimination, and that's not going to be allowed. So as long as you've got a rational idea, and I think I'd given in some of the classes the example of the amusement park rides. Have you ever gone to an amusement park and it says, you have to be this tall to ride?
They're terrible.
Well, the idea, technically speaking, they're discriminating on the basis of your height. Of course, you could make the argument that if you're so small, you're going to fly out of the roller coaster and die when it does the spin. It's not really no rational basis. They're discriminating against you, but the idea is it's for your own good or for your safety. So that's what invidious discrimination is. Go ahead.
What if you apply for a job where, yes, you do have some type of physical disability,
Mm-hmm.
and they don't hire you, but they are in their means to actually accommodate that particular job for you to actually do that?
You know, let's not do that today, because we just need to get through the review stuff, and that could be like 100 different answers. But go ahead.